Amendment into play. The Fourth Amendment protects people, not places. So they basically just tapped a wire phone knowing that he would come use it. And did he have a reasonable expectation of privacy when he closed the door to the payphone and thought he was going to have a private conversation? Yes. Any questions on cats?
What year was it?
That was
1967.
Sweet. Okay.
I wrote down the dates.
Aha, that's right. The last slide had all the dates. Boom. Okay. So she can tell you what the dates are for the next. Smith versus Maryland. Basically, this deals with third party. The question, on March 5th, 1976, Patrick McDowell was robbed in Baltimore. She was, yeah. You can read it. Basically, what happened was they used her, they used the third party, the telephone company, to grab information without a search warrant, I believe. Let's see. Oh yeah, Smith. Okay, so basically, they grabbed information from a third-party company. The continuation of this is, does the installation and use of a pen register constitute a search under the Fourth Amendment? So basically, that would be like saying, does the government using Yahoo as a third-party registrar violate the Fourth Amendment? The conclusion is no. Justice Harry Blackmun delivered the opinion of the 5-3 majority. The court held that the Fourth Amendment protections are only relevant if the individual believes that the government has infringed upon the individual's reasonable expectation of privacy. A reasonable expectation of privacy doesn't happen if you click agree to the terms and conditions. You reasonably expect that your privacy is going to be given over to that third-party company, therefore the government can go to that company. So you really don't expect or have a reasonable expectation of privacy when you agree to terms and conditions. That's very important. Okay, any questions on Smith versus Maryland? Okay, United States versus Knotts. This was really good. It reasoned that a person traveling in the public has no expectation of privacy in one's movement. Since there was no search and seizure, there was not a Fourth Amendment violation. That's basically just public thoroughfares. If you travel on public thoroughfares, your privacy is gonna get violated by the government because they're allowed to. Because everybody else can violate your privacy. Because everybody else can see you on that public thoroughfare. The government should be able to see you on that public thoroughfare. The government should be able to track you on that public thoroughfare by putting a GPS beeper on your car. So check the underneath of your car so it doesn't have a GPS tracker on it. Yeah.
Recently, this is an argument about, very specifically pertains to gun laws, how people get arrested for having a weapon in their car on
Yeah.
property, the whole your car is your castle argument, something like that.
Yeah.
Would that apply if you have a reasonable expectation of privacy in your car?
No, not if, okay, it depends on where you are at. If you're at a public school, they can totally kick you out of the public school and fine you and put you in federal prison because public schools legitimately have a law, there's no guns or rules on campus. So even if it's in your car, like one dude came on campus with a fishing knife, and they prosecuted him because he brought a knife onto campus. So that just, the way the government does that is completely arbitrary. But your car, it really doesn't apply. Now maybe traveling, or honestly with cars, the Supreme Court has ruled against cars almost every time it's come up. So is really sad, but it doesn't have any bearing. You don't have any privacy because when you're in your car, it's intended that you're going to travel somewhere. When you travel somewhere, it's generally going to be to a public place. When you're in a public place, everybody else can see it. Therefore, the government has the right to survey it. So, any questions? United States versus Knotts. Public thoroughfare rule. U.S. versus Oliver. This one was fun. These are the there was 2 consolidated cases involving discovery of open marijuana fields used as a result of unwarranted searches of privately owned land. In the first case, Kentucky State Police searched Robert E. Oliver's farm. Acting on reports of marijuana was going to hear a gate marked with no trespassing signs surrounding the field. Police found marijuana in the field about a mile from Oliver's home. Before trial, the United States District Court of the Western Court of Kentucky suppressed evidence found in search of the ground, on the ground that Oliver had a reasonable expectation that his field would remain private. This expectation triggered the Fourth Amendment's protection against unreasonable searches and seizures. So he had a no trespassing sign, so that means he had an expectation that people weren't going to trespass. He didn't just put it there to keep bunnies off the field. He did it to keep people off the field. That's a reasonable expectation. The Supreme Court is very common sense in their adjudicating of common and reasonable expectations of privacy. And you can tell that to the judge. If you think you have a reasonable expectation, the Supreme Court's going to rule that you have a reasonable expectation. So the question, does the open field doctrine apply when police officers knowingly enter private-owned fields without a warrant? Legal provision. Fourth Amendment, yes. Justice Powell wrote for the majority, stating that the open field doctrine applies in both cases. Individuals cannot legitimately expect privacy for activities conducted out in the open except in the area immediately surrounding their house. Now, this brought up an interesting question, because up until that point, the court had ruled in favor of people having a reasonable expectation of privacy. The problem was, it's a field. If you fly over that field, you can see it. If you use a helicopter, you can see it. If you use binoculars, you can see the fact that there's weed growing there. And so they reversed themselves and said that there wasn't a reasonable expectation of privacy, even though there was a no trespassing sign, because it was out in the open and everybody could see it. And this is kind of the contradictoriness of the Supreme Court, which is really helpful for you as a negative team. Yes?
Wait, so if it's like an open house, then it's okay, but if it was like a greenhouse or something, where it'd be like covered, then it wouldn't be okay?
Well, it depends on if it's like you could see through like the glass in the greenhouse. Because you can, a lot of times, like a botanist can see a plant from far away and tell what it is, you know what I mean? So it depends on if what you can see. If the greenhouse is all black, then yeah, if it's covered by black tarp. But if it's a glass greenhouse, then you can kind of just look at it and see it, yeah.
Can't you argue that the most recent court cases are the only ones that apply? Like, if there's two contradictory cases?
You can argue that, but there's also the whole idea of stare decisis with the Supreme Court, which is Latin for let the decision stand, which means that when you bring up precedent, it's more powerful than when you bring up current cases. So a lot of times precedent, when you argue from an old court, it a lot of times has a lot more weight with this Supreme Court than when you argue, because when you argue from a decision they made, it's kind of like pandering to them. You're like, hey judges, I know you agree with me because you guys decided this 5 weeks ago. When a lot of times you're like, you know what, the old court decided this, and you guys got to suck it up and have the guts to agree with your predecessors. And sometimes they respect that, and they really like that. So that's what happened in Oliver. Any questions on Oliver? Oh, this is really good. Thurgood Marshall wrote a dissent contending that the law should protect private land that is marked as such against unreasonable searches and seizures. Justice Brennan and Justice John Stevens joined Marshall's dissent. So the court was a little bit split on this one, but 6-3 is a pretty good majority. All right. Caro. Defendant James Caro, Richard Horton, and William Hurley ordered 50 gallons of ether from a government informant to be used to extract cocaine from clothes imported in the United States. I don't even know how to pronounce that guy's name. The informant and owner of the ether gave consent to the police to install a tracking device into one of the cans containing the ether before delivery to the defendant. So basically what they did was they knew there was a shipment coming in, so they put a beeper in the shipment, knowing that the guys would pick it up, knowing that they could then track those men. And you guys can read the question. Does the installation of a tracking device into a container without the permission of the original owner constitute a seizure within the meaning of the Fourth Amendment when the container is delivered to a buyer having no knowledge of the tracking device? So a lot of times, the owner won't have knowledge of the tracking device, which is pretty big. And the legal provision, Fourth Amendment, no. The court found that although the cans of ether may have contained an unknown and unwanted object, no meaningful interference with the defendant's interest in their possessions occurred, as the tracking device was installed before the defendants obtained the ether. So not only, it was not the defendant's property. It was instituted, it was tracked, so like if they put a tracking device on a car that was still in the lot and someone came and bought that car, that wouldn't be a violation of Fourth Amendment because they wouldn't have had a reasonable expectation of privacy because the government would have just put it on the car before anybody owned it. All right, this one's fun. California versus Iralo. Dante Carlos Uralla grew marijuana plants in his backyard. Bad idea. Shielded from view by 2 fences. After receiving an anonymous tip, the Santa Clara police sent officers into a private airplane to fly over and photograph his house at an altitude of 1,000 feet. Based on an officer's naked eye observation, a search warrant was granted after the trial court rejected Uralla's motion to suppress the evidence under the exclusionary rule. He pleaded guilty. The California Court of Appeals reversed the decision, holding that the aerial observation violated the curtilage of his home and therefore the Fourth Amendment. So here's where it directly clashes with curtilage. Now, how many of you know what the fruit of the poison tree doctrine is? Okay, awesome. Basically what that means is that the government cannot convict somebody with evidence that is attained in absence of a warrant. So they can't say, oh look, that guy had marijuana plants. Hey, we're going to go arrest him. And let's go get a warrant to arrest him because we illegally saw the fact that he had marijuana plants. That is called fruit of the poison tree. You cannot use evidence in a court of law that was obtained in absence of the legal law, which is really interesting. And that applies to a lot of stuff. So if someone says, we're going to solve crime by this really cool surveillance law, you're like, great, that's really cool, but you're not going to solve crime because you can't use the evidence that you obtained in a court because it was obtained illegally. Beautiful argument, love it. All right, the court's decision. Chief Justice Warren Burger, who's got an awesome name, wrote the 5-4. This one was split because it dealt directly with curtilage. There we go. Katz versus United States. He concluded the Fourth Amendment simply does not require the police traveling in public airways at this altitude to obtain a warrant in order to observe what is visible to the naked eye. So this was a very interesting case because it wasn't like the police looked through with like a thermal camera into his house and saw the plants, like violated his curtilage. Joe Schmo flying in a Cessna 178 could have seen the marijuana plants too with binoculars. So if it can be seen by a normal person, then the police can use it to convict that individual. Now then the question is, what if some high-tech rich billionaire gets the ability to use a thermal camera? Can the police then use thermal cameras? No. You know why? Because the thing that the police use has to be available to the general public and generally and widely used among the public. So the police can only use, if they want to stay within the bounds of the Fourth Amendment, only use binoculars, GPS tracking devices that are used by the general public and used by private investigators, and things that are generally and availably used. Like thermal cameras cost a lot, so they can't just go ahead and use a thermal camera because not a lot of people have a thermal camera. Yeah.
Yeah, but as technology increases, like in like 10 years, who's to say they won't have like thermal imaging?
Right. And then at that point, the police could use it. However, it's not the availability, because anybody can go buy a thermal camera. It's, is it in general use? So is that thing in general use? Not is it generally available, because anybody can go buy it, but is everybody using one? Yeah.
Would the Supreme Court decide whether that was a technology that was generally used, or do they make a new law?
No, they would basically run a test to find out whether or not it was generally used. And there's some really good, like the Supreme Court just comes up with arbitrary tests and decisions, and I don't blame them because they have a hard job. They got to really just decide and interpret a lot of these laws. All right, anybody have any questions on Iralo? Okay, let's burn through this sucker. Okay, Kylo. Speaking of thermal, Department of the Interior used a thermal imaging device outside of Danny Lee Kylo's home in Florence, Oregon. According to the district court that presided over Kylo's evidentiary hearing, the device could not penetrate walls or windows to reveal conversations or human activities. The device recorded only heat being emitted from the home. The device showed that there was an unusual amount of heat radiating from the roof and the side walls of the garage compared with the rest of the house. The assumption is that to grow marijuana indoors, one needs to provide a large amount of light in order for plants to photosynthesize. This information was subsequently used to obtain a search warrant. See? So they used evidence that was obtained in absence of the law to grab a search warrant to then go search his house.